Thank you for joining me. Chuck Morse here at Left Right Radio. My guest is Adam Winkler. He is a professor of constitutional law at the UCLA School of Law. He is the author of Gunfight, The Battle Over the Right to Keep and Bear Arms in America, and his latest book, We the Corporations, How American Business Won Their Civil Rights. Adam, thanks for joining me this afternoon.
Thanks so much for having me.
Adam, the history of corporations obtaining and establishing their rights is one that you parallel with the civil rights movement, and sort of intersect the two in that the civil rights movement can learn lessons legally from the long history of corporations establishing themselves. Talk a little bit about the thumbnail of your book, and also about the business. We'll get into it also of corporations as people, which I've heard so much gnashing of teeth about on amongst liberal talk show hosts.
Well, that's right. I mean, Citizens United and Hobby Lobby, these cases that have extended fundamental rights like political speech and religious freedom to corporations, are thought to be a kind of new thing, a new development. But in truth, corporations have been fighting for equal rights for over 200 years. And like women and minorities, corporations have been going to the Supreme Court seeking landmark rulings extending the Constitution's most fundamental protections to them. Now, of course, corporations don't march in the street and try to win over the hearts and minds of the people, but corporations have been remarkably successful at winning over the hearts and minds of the justices of the Supreme Court, and today have nearly all the same rights as you and me.
Now, the concept of a corporation ultimately is really nothing more than an organized group of people who set up a kind of an establishment to offer goods or services to the public, or in the case of a nonprofit organization, corporation, it's a think tank. It's not necessarily always based on a for-profit model. But it seems to me that from a constitutional standpoint, that falls under the aegis of the First Amendment right to assemble and right to be, which is an extension of the right to free speech and the free press, wouldn't you say?
Well, the Supreme Court has never held that you have a fundamental right to form a corporation, but once formed, the Supreme Court has recognized corporations as entities to have individual rights. And often the logic of those cases has not been based on the idea of corporate personhood, which under corporate law today means that a corporation is its own independent entity in the eyes of the law, wholly separate from the stockholders or the members of the corporation. Today, the Supreme Court generally extends rights to corporations with the idea that it really is an association. It's not a person, but a group of people who've come together, and that in order to protect that group of people and their rights, we need to protect the rights of the corporation.
And that, in a sense, the development of corporations is a great reform from what had existed previously in colonial times, which was a mercantile system by which the state was the corporation, in a sense, and that the corporation was an extension that existed at the whim of the state. The corporation has a relationship with a state. I mean, in the case, a lot of them do it in Delaware because they have liberal corporate laws, but nevertheless, it has obligations to the state, but it's an independent entity that operates under the law for its own self-interest. And that's actually a very progressive development in the real sense, is it not?
Well, the idea of the rights of businesses have been promoted by progressives for many years in many circumstances. And indeed, we find, if we look back through the history of Supreme Court cases granting rights to corporations, we find surprising bedfellows that Roger Taney was a big believer in democratizing the corporation and limiting the rights of the corporation. In many ways, it was the New Deal and Warren courts of more recent years that have expanded the rights of corporations in ways that sort of set important foundations for Citizens United.
And one of the first cases brought before the Supreme Court, if I'm not mistaken, was Dartmouth College versus New Hampshire. And it was argued by Daniel Webster in that Dartmouth College claimed its right to be a separate corporation from the state of New Hampshire. Would that be accurate? And what was that about?
That was one of the earliest corporate rights cases. It wasn't the first. The first was actually a decade earlier in 1809. And to think that the first Supreme Court case on the rights of business corporations was decided in 1809 is pretty shocking when you realize that the first Supreme Court case on the rights of African Americans wasn't decided until 1857. The first Supreme Court case on the rights of women wasn't decided until 1873. So a half century earlier, corporations are in the Supreme Court seeking individual rights. And Dartmouth College was one of the earliest cases. And Daniel Webster was the notable lawyer for Dartmouth College. And indeed, Webster was one of the most influential lawyers in early America and argued many of his cases on behalf of business corporations. Dartmouth College was not a business corporation, but his victory in the Dartmouth College case led the Supreme Court to declare that corporations were essentially private entities and that they didn't have to serve a public purpose and they didn't exist at the whim of the public. It was a fundamental transformation of the nature of corporations and really made corporations private entities, whereas, like you said before, they were previously much more associated with the state and doing state purposes.
And it makes sense from a common law standpoint that a corporation should be extended the same rights as an individual, which is a certain degree of sovereignty under the law, because a corporation is a group of individuals who come together voluntarily to represent their interests. And as such, the corporation itself as an entity requires a certain amount of immunity and a certain other privileges in order to function, just like an individual would, although a little bit differently because of its nature. And it's a progressive idea. Yep.
Well, for a long time, the Supreme Court hewed to a line. It said that corporations had property rights under the Constitution, protection for their properties, so that the government couldn't seize their buildings and assets without paying just compensation, couldn't declare them guilty of crimes and fine them enormous amounts of money without proving beyond a reasonable doubt and affording corporations due process of law, constitutional rights. At the same time, what I think has gotten the Supreme Court in a bit of hot water or controversy recently has been the extension of what we might call liberty rights to corporations, rights associated with political freedom and personal conscience. Because it's true that some corporations do really reflect the idea of a voluntary group of people who come together to support some particular end. You know, it's hard to think of many of the, especially publicly held corporations today, in that same light. I mean, many of us invest in the major public corporations of the day through pension funds, but we don't really even know which corporations we're invested in through those pension funds. They don't tell us, and we don't have much choice. So to think of us as sort of voluntary members supporting whatever Exxon wants to spend on politics seems like a stretch.
Yes, but ultimately, most Americans have some investment in corporations at some level. Now, the Citizens United decision gets into the question of whether corporations can get involved in politics, whether they can actively support candidates for office or political causes. And yeah, it's interesting that a lot of commentators on the left rail against this, I think out of a sense of class consciousness and out of a dislike for private ownership, and very hypocritically, because a lot of corporations support very liberal causes and candidates. Putting that aside, they have been the major spearhead against the Supreme Court decision, Citizens United. Talk a bit about Citizens United and how that accurately and rightfully reflects rights of corporations and why that's good.
Well, I don't know that I would agree with your conclusion that corporations should have those rights and that it's all good. But Citizens United is not the novelty or the work of sort of conservative judicial activism that it's often accused to be, at least in the idea that it expanded rights to corporations. There were aspects of the decision. The court reheard the case, re-argued the case to address this bigger issue when the lawyers themselves hadn't asked for it. So it looked a little bit like judicial activism in that way, but it was not judicial activism in extending rights to corporations. And in fact, the Supreme Court 30 years earlier, in a case called the Bellotti case, had said that corporations have political speech rights under the First Amendment. And if you go back to the 1930s, one of the important precedents that was cited by Citizens United was a case brought by Louisiana newspaper companies against Huey Long that established broad protections for the freedom of the press and recognized that corporations through newspapers play a pretty important role in checking the government and encouraging democratic debate. So the rights of corporations, I think, doesn't really, when we get down to it, track neatly along partisan lines.
And also the business of judicial activism, and that the claim that Citizens United represents that. I would like you to define that concept a bit more carefully, because my understanding is that if a decision is rendered by a judge or by the Supreme Court justices that is consonant with the Constitution in its original intent, or even with basic case law, it's not judicial activism per se. Even if they, and whether or not they go off the case that's in front of them, that's something that actually, I think that happens fairly regularly in court cases, that something is tangential to it. It's not necessarily directly to do with it. But in this case, it seems to me that that decision, Citizens United, did not deviate from constitutional principles. In fact, it enhanced them and further defined them.
Well, and the ACLU and many other free speech organizations would really agree with you. And many people feel that Citizens United was rightly decided. And of course, 5 justices on the Supreme Court believe it was rightly decided and a proper interpretation of the Constitution. I think one thing, when we think about judicial activism, often that's just a terminology that we use to describe cases we don't like the decisions that come out of. But there were elements of Citizens United that were somewhat troublesome. The court did overturn many years of precedent saying that corporations could be subject to special limitations in the political process. There was a long history and tradition of restricting corporate money in politics. And the court also, as I said earlier, reached out to decide this broad constitutional question about the rights of corporations, even though the advocates challenging the law hadn't made that claim and hadn't sought that kind of broad remedy. But nonetheless, I think it is the question of whether corporations should have free speech rights is a very complicated one. And indeed, Ralph Nader was one of the people responsible for giving businesses the speech rights that they have today, because he was seeking to protect consumers and won landmark Supreme Court cases that recognized the value of speech to the listeners, regardless of the identity of the speaker, a principle the court cited in Citizens United.
And also the concern by the opponents of Citizens United shows its own hypocrisy when they wanted to give an exemption to unions. And that unions are, in fact, if you take a look at the 10 biggest donors to the Democratic Party and to liberal causes, it's 6 of them are unions. So, it was kind of stacking the deck, and it was not, hardly based on any kind of fundamental embrace of constitutional principles.
Well, Citizens United did extend its protections to unions, of course. And
right.
Indeed, years immediately after the decision, unions were some of the biggest spenders under the Citizens United decision. And indeed, while Citizens United has freed up corporations to spend more money on elections, its biggest impact has really been in freeing up individuals to spend money on elections. The question is whether that will maintain, or whether corporations will become more used to these new ideas. What we've seen previously in campaign finance law is that corporations are not first movers. They generally stay on the sidelines until there's more legal certainty about what they can do and more market certainty about how consumers will take it. I do think we are seeing corporations being thrust into the political spotlight more than ever. You see it in Parkland after the celebration of all these companies that have abandoned the NRA. People, and especially millennials, are looking for their corporations to share their values, and that, if anything, will lead to corporations being more active in politics.
Right, and corporations generally try to avoid politics because they're offering goods and services to the public. They don't want to alienate any portion, and usually when they are contributors to candidates, it's more of they contribute to whoever they think is going to win. It's not so much ideological. I mean, Barack Obama got more corporate donations than any candidate in history because they sensed, and rightfully, that he was going to win. It wasn't necessarily based on ideology. The Hobby Lobby case sort of bleeds into religious questions, that this particular corporation, Hobby Lobby, had religious objections, ethical objections to financing birth control for its employees. What say you about that? And does a corporation have a right to make those decisions?
Hobby Lobby was a controversial case. What Hobby Lobby said was that the corporation, this national chain of craft store with tens of thousands of employees, was entitled on the basis of religious freedom to an exemption from a requirement that they cover birth control in employee health plans. And this is an example of when we give the rights to a corporation, sometimes at least, it can interfere with the ability of individuals to gain the benefits that the law provides them. Because Hobby Lobby was entitled to an exemption, and as a result, the employees of Hobby Lobby no longer have birth control covered in their health insurance plans, whereas the employees of similar companies receive that legal benefit.
Right.
So Hobby Lobby was a controversial case, and we're seeing maybe that the religious and First Amendment rights of corporations are going to expand even more. This term, the Supreme Court has a case dealing with a Colorado bakery that refused to sell a wedding cake to a same-sex couple. If the court grants an exemption there, I think Hobby Lobby and Masterpiece Cake Shop will really provide perhaps a scary license for businesses to be able to discriminate on the basis of sexual orientation.
Well, let me just go into that a little bit, because my understanding is that with the cake case and other cases like that, it wasn't that they were discriminating against a gay couple or wanting to have a cake made. They could go in and buy whatever cake they want. I mean, that's outright discrimination. They can't say you're not allowed in this business because you're gay or anything like that. But what it was that the customer was actively telling the baker, you have to make the cake this way. And in a sense, it interferes with artistic license, I think. I mean, it would be like, let's say somebody came in who was a part of Hitler Youth, and the baker's Jewish, and they said, I want a wedding cake in the shape of Hitler's mustache. I don't know. I mean, it's not, doesn't the baker have a right to say, look, you can buy the cakes we have here. You can buy my products, but you can't make me create something that I don't want to create.
Well, the truth is, if we say that, then we would allow a baker who doesn't want to provide a wedding cake for a same-sex, for an interracial couple, so doesn't want to support African Americans, and just to say, well, I'm not going to provide a cake for African American people. Yeah, you can come in and buy anything you want, but I won't custom make a cake that celebrates a wedding that I oppose. And in truth, the facts of this case are not really so beneficial to the baker, although I think he's likely to win this case. The couple came in and said, we would like to talk to you about buying a wedding cake. And he told them he wouldn't sell them a wedding cake. So they never even got into the discussion of what the customized cake might look like. And it's not clear that there was any real customization that was necessary. But even if there were, look, all services that we buy, or a lot of services that we buy, are customized. The wedding invitations are customized. The wedding floral arrangements are customized. The wedding table filled with food is customized. If we allow exemptions, anytime someone provides something custom made, we're providing a lot of exemptions for.
Or should the photographer be forced to film a gay wedding if they object to it? And by the way, I personally think it's ridiculous that they would object to it. But from a strictly legal standpoint, as much as I would think it's despicable for a baker to tell an interracial couple he's not going to make a cake for them, the answer to that legally would reside more in our culture and in our public life, in that we would boycott that baker. We would expose the baker, because the baker's business is based on their reputation. And if that is run up the flagpole that they did this, they'd lose their business. So there's social pressures that are natural and that would take care of that kind of a thing. It doesn't necessarily have to cross into a legal question where they have to, by law, or they'll be penalized. They could even ultimately be jailed if they don't abide by it.
Well, I think there's a lot of parts of the country where a bakery that refused to sell a wedding cake to a same-sex couple would be celebrated by the local consumers, not boycotted by them.
Right, that's true.
I don't think we should leave people's individual rights to the vicissitude of the marketplace. We've been here before. When the Civil Rights Act banned racial discrimination in public accommodations, it was challenged immediately by big businesses and small businesses that didn't want to serve a racially integrated clientele. And they claimed it would destroy their businesses and that they had constitutional rights at issue. The Supreme Court in those cases said, no, you don't have a constitutional right to an exemption from civil rights laws. I don't know that the Supreme Court, and today it's unthinkable that people would discriminate on the basis of race in public accommodation. I hope the Supreme Court doesn't make the mistake of allowing discrimination against LGBT people to occur the way it didn't allow racial discrimination to occur.
As would I. I mean, obviously, a gay couple can go into a public venue that's open to the public and that's offering a service. That's not the question. The question is whether or not that public service has to perform a certain function different than they perform for everyone else that comes into the venue. But it's a very complicated question, and it's something really that, we ought to have an examination from all sides on. Anyways, Adam, listen, where can people get your book? Once again, introduce your book to my listening audience and talk a bit about it.
Sure. It's called We the Corporations. I think I have one over my shoulder right here. How American businesses won their civil rights. It is available on Amazon or at independent booksellers near you. Also available on Kindle or whatnot. And I've written some nice excerpts on the book if people are interested in a variety of different venues. New York Review of Books, among others. I encourage people to check it out.
Well, listen, Adam Winkler, I want to thank you for joining me this afternoon. I appreciate your time, you're taking the time.
Thanks so much.
All right, take care. Okay, Chuck Morse here. I shall return the usual time tomorrow at 12 a.m. I've got the national spokesperson for the Libertarian Party. Have a good day, everybody.